It's about dang time. A fifth juror has officially come forward, and we got the affidavit. Hello, 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 and welcome to Alexasrewm, where we are not lawyers, we are not medical professionals, we are not law enforcement, we are just people who have opinions about all things going on in the true crime community, including what the heck is going on with my freaking hair right now. Oh my God, I'm so sorry, guys. I hopped out of the shower. I'm in the middle of packing, so please ignore the mess behind me. Me and my wife are heading home for the weekend, so please bear with me. But I want to make sure I got this news out to you because, yes, in fact, a fifth juror has come forward, pretty much agreeing and confirming what we already know from the previous four jurors that have also signed affidavits, saying that yes, the not guilty verdict is correct. We were unanimous on 12-0 for counts 1 and 3. So I want to get into this as well as the second supplemental affidavit that Alan Jackson filed as well, too, signed and filed in support of the defense's motion to dismiss. So let's take a read through this, and then we'll hop into Alan Jackson's supplemental affidavit. Now comes the defendant, Karen Reed, by and through undersigned counsel, and hereby respectfully submits this second supplemental memorandum in support of her motion to dismiss, filed July 8th, 2024. As reflected in the attached affidavit of Alan J. Jackson, a fifth deliberating juror, Juror E, has confirmed that the jury was unanimous on counts 1 and 3. Remember, that is the murder 2 charge, which is the count 1, and then count 3 is the leaving the scene of personal injury and or death charge. That Karen Reed was not guilty of those charges. Alan J. Jackson, second supplemental affidavit, paragraph 4. Based on the attached affidavit and all of the reasons set forth in its opening motion for supplemental memorandum and reply, because remember, they did reply the other day. If you didn't check out that video, I will link that in the description below so you can catch up to speed there and how they responded to the Commonwealth's opposition to their motion to dismiss. The defense respectfully renews its contention that the jury acquitted Miss Reed on counts 1 and 3, or alternatively, there was no manifest necessity for a mistrial as to those counts, and therefore the double jeopardy protections of the federal and state constitutions require that those counts not be retried. If the court would prefer to rule on the basis of affidavits executed directly by the jurors, the defense respectfully requests permission to initiate contact with jurors A, D, and E. Exactly. So if you guys have a problem with it, then let us do the due diligence and speak to them, because that's the next step. They can't just go willy-nilly making contact or coercing these people into confessing something. That's not how this works. So what they're asking right here from the court is to get that permission so that they, yes, can open up potentially setting a date for an evidentiary hearing if there is in fact something worth digging into. Let us at least do the due diligence of confirming directly from the horse's mouth, just like I talked about in my video from the other day too. If you are so worried that what we're alleging at this point, we have 5 signed affidavits. I don't know what else more you want other than to hear it from the horse's mouth. So let's go get the dang horse, is how I'm reading it. For the sole purpose of asking them to affirm the accuracy of the 3 affidavits of Alan J. Jackson. So short, sweet, to the point. But yeah, exactly. If you have an issue with it, then let's go. Let's get these affidavits signed, get them affirmed, get them signed, and sent directly, if they need their own lawyers too, sent directly to the court affirming this. So now I want to get into the second supplemental affidavit signed by Alan Jackson. So this is again in support of their initial motion to dismiss. I, Alan Jackson, declare I am a partner. Again, this is just as saying, hey, this is who I am. This is how I've come to know Karen Reed, etc. On Wednesday, July 17th, 2024, I was contacted by Juror E. So yesterday. And you have to Yeah, I have to wonder too, with just every single day. I mean, more and more and more people are just getting involved in this case and tweeting information. And I know a lot of people in the opposition are going to say, Dartle Law is intimidating people and trying to coerce. No, no. These people have a conscience. And why would they risk? These are ordinary people, right? Why would they go to bat for a woman they don't know if they didn't feel at least somewhat responsible for the potential decision that's going to be made in regards to what happened? I know I would. I can't imagine the kind of weight that would carry. I can't even imagine to know that I know the truth. And they're serving their duty to the fullest, and I absolutely commend these people because, again, you're opening yourself up to public scrutiny. Granted, less so because more people realize that, yeah, Karen Reed is factually innocent, but, I digress. But they're potentially opening themselves up for public scrutiny. These are people also from that community as well too, from the Dedham County. So, eh, I mean, I can only imagine the rumor mill spills. Eventually, their identities will likely be known, at least in their community. Maybe not confirmed 100%. No matter what the court wants to do in terms of impounding that and trying to seal their identities from the rest of the world, for sure. But within their community, I mean, I can only imagine people probably are already speculating as to who these jurors could have potentially have been. I can't imagine the kind of secret that holds. It's just trying to keep it in and not explode when people, speculators on the sidelines, are saying, "Hey, that like questioning this and questioning that," when in fact they were in the room themselves. So again, I have to commend each and every one of them for at least coming forward in some kind of way. Even the intermediaries and the informants, who are also putting their reputations on the line too, because I'm not saying at all do this at all, but I mean, you probably could figure out who these people are if you did enough digging, and please don't do that at all. Respect their privacy and let the law play itself out. But I mean, I can't even imagine. I can't even imagine. So yesterday, literally yesterday, and I can only imagine how many more people are going to come out probably today and maybe even over the weekend, tomorrow too. Based on my conversation with Juror E, that the juror's physical description of himself or herself was where that juror was seated, and the juror's name and occupation, which was also disclosed during the voir dire process. I was able to positively identify Juror E as a seated deliberating juror in the trial of this matter. Juror E stated that he or she decided to contact me to provide information about the results of the jury's decision making following deliberation. So there you have it. I mean, and this is the same thing too, and I'm not going to compare apples to oranges, but when all of these people say, well, if this person was really a victim of, again, take the Diddy case or whatever, any kind of SA case like that, where they're like, well, why didn't they just come forward right away? And again, I know these are two completely separate issues, but it has to go with the idea that, yeah, people don't want to be the first. People are afraid to be the first to come forward. But once one person has the courage to come forward, no matter what it is, even if your identity is sealed from the public, it gives other people the confidence to come forward and to do the right thing. So to scrutinize them for waiting this long to come forward because, oh, the hearing's coming up on Monday, and why didn't they speak up? That it No, you're not blaming the right people. You're not. You're not. And I think we're just going to see more and more people. Okay, like, five people came forward. I guess I'll come forward too. Like, what do I have to lose? And I can only imagine too, since they're involved in a text thread, if that's also going to come into play if there is an evidentiary hearing. Is that something that the defense and as well as the Commonwealth, but is that evidence that the defense can get access to? I imagine so. Their conversations, and I'm sure that people or the jurors in the group chat are like, "Hey, yeah, I just came forward too. Like, don't be afraid. I'm only speculating, but I can only imagine that's what the conversation is right now. So back to this, Jury E said, "Yep." Following the deliberations, Jury E explained that the jury was unanimous on 1 and 3, that Karen Reed was not guilty of those charges. Juror E went on to state that the only count on which the jury was deadlocked, now this is very interesting information, was in relation to the lower charges on count 2. I took that to mean the lesser included offenses associated with count 2. This statement seems to coincide with everything else that has been said previously. Everybody's story is the same. It doesn't seem like one person saying this one thing and one person saying, "Oh no, like we weren't intimidated," or "Oh no, actually we were really hung up on this." Everybody's story is consistent. Everybody's story. So again, I can only imagine more and more people are going to continue to come forward and get that courage, especially if these people are all in contact with each other as well too. And this is the thing, guys. Remember when Alan Jackson brought up that the issue with, or the potential issue with, the original verdict slip form, and why it can be confusing, is because it almost seemed like the court was trying to guide the jurors into making a verdict on a guilty verdict on the lesser included charges. And if that is the issue where people were most confused on, that needs to get cleared up like ASAP. You can't possibly present these exact charges in the same way in a second trial and expect a whole new batch of jurors to understand what the heck you're talking about. If it's confusing to one pool of people, these are 12 individuals, all of different academic backgrounds, all of different professional backgrounds, all of different familial backgrounds and ethnicities and political views. So, again, if it's confusing to 12 people, it's probably going to be equally confusing to another set of 12. But that's just my opinion. Let me know what you guys think in the comment section below. 6, Juror E indicated that he or she was happy to provide such information, but wished to remain publicly anonymous. So, yeah, and I don't blame them at all. Foregoing is true and correct to the best of my knowledge and belief, under penalty of perjury, under the laws of the United States and the state of California and the Commonwealth of Massachusetts. Executed the state of July 18th at Los Angeles, California. So, I mean, wow, 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 wow. What a time. Am I right? What a time for me to be traveling to, of course, when I can only imagine what's going to happen on Monday. Remember that Monday hearing is going to start at 2 p.m. Let me know if you guys want me to live stream that, or if you want me to do like a recap video. I have no idea how long this is going to be. I don't even know. I mean, still, it's labeled as a trial assignment conference, so it could be a 10 to 15 minute nothing burger. Ben might come in and say, "Hey, I don't want to deal with this today. Can we use this time right now to figure out, or maybe even hear arguments?" I don't know. Hear arguments about the motion. It could be long. It could be an hour long. It could be 2 hours long. I have no idea. Or it could be like, "Hey, let's find a date to figure this thing out. When can you get Alan Jackson in here?" Because I cannot imagine that the judge is going to rule on this on Monday. I really don't think so. I don't think she can. I don't think she can. I think the only thing she can do is say either, "Yes, you can take that next step and initiate contact with the jurors," or to affirm that what they said in their affidavits is correct, or, "Nope, sorry, throwing this out." But I can't imagine that's gonna happen at this point. I mean, I know it's Bev, and I know I go back and forth on this, but I feel like the more people come forward, like, her hand is getting more and more forced. But again, we never know. Bev is who she is. Bev is Bev. So let me know what you guys think in the comment section below. What do you think about the fifth juror coming forward? The truth hopefully will come out. I mean, at this point, five jurors have come forward, right? We have 5 people who are ultimately willing to affirm that yes, this was in fact the real split. It was 12-0 on counts 1 and 3, and hopefully at the end of the day, yeah, Karen Reed can get justice, John O'Keefe can get justice, and we can all live happily ever after. I mean, that's just wishful thinking, but hopefully we can, in doing this and getting justice for both of them, that we can make this place a little bit better to live in. That's what we always aim to do here on this channel, which is why we report this news. So thank you so much for watching. If you like today's video, make sure you hit that subscribe button. Make sure you hit the notification bell so you never miss another video from me. And make sure you hit that like button because it shows the YouTube algorithm that this is newsworthy news. And it just further, again, incites that we have to put pressure on these agencies, on the DA's office and the state of Massachusetts. Thank you so much for watching, and I'll see you in the next one.